I'm Lucy Beednell with the ARC of Northern Virginia. This 3-minute webinar, thanks to a grant from Virginia Board with People with Disabilities, will help you understand some common myths about guardianship. Understanding and debunking these myths is really important to deciding what's the right type of legal authority to put in place for someone with a developmental disability. The first myth we hear often is, "I have to become guardian," and that's false. There's no law or mandate for people with disabilities to have a guardian or for parents to become those guardians. There are lots of free alternatives that the law actually says you should consider first, like powers of attorney and supported decision making. All people with developmental disabilities need guardians is false. Actually, the overwhelming majority of people with developmental disabilities don't need a guardian, but they may need help making decisions just like everyone else in the world. Guardianship should really only be put in place when less restrictive options have been found to not provide the support someone needs. Parents often fear that if they're not guardian, no one will talk to them, and thankfully that's not true. Signed consent to exchange information forms or powers of attorney can be used to make sure information is shared in real time or after the fact, whatever the need is, with other parties involved. And this protects the right of the person with a disability. Powers of attorney can be totally customized to the need and situation. We hear that guardians can prevent abuse, and unfortunately, there's never been a study that shows just having a guardian in place prevents abuse. What we do know prevents abuse, neglect, and exploitation are people with disabilities who have the best level of self-determination. That means who feel empowered to make their own choices. So when you have a team around you helping you make decisions and you know that your thoughts and opinions are respected, that makes you less likely to be abused. We often hear it won't hurt to put guardianship in place, and that's not the case. Guardianship is expensive, usually several $1,000s, and permanently removes rights that are really important for people with developmental disabilities. Once a guardian's in place, someone always has to fulfill that role, which can create a big long-term planning burden. Instead, consider something like a circle of support or supported decision-making where you develop a team around you who knows what you need and how to best support you and work with you. Someone fears that if they're a guardian, they can prevent arrest. And unfortunately, that's not true. Guardianship doesn't provide any protections at all against arrest or incarceration and doesn't provide the guardian with any special rights during a trial or interrogation. Someone with a disability can always ask for supporters to be in place. People with guardians can't be financially abused is another big myth. If money is taken away from someone in a scam or other sorts of illegal schemes, a guardian has no power to get that back other than using regular law enforcement like anybody does. Low-cost or free tools like powers of attorney, able accounts, and special needs trusts can protect money and assets, though, without removing rights. Be sure to check out our online supported decision-making resource library and other national supported decision-making tools. And anytime, ask us a question at thearcofnova.org/answers about supported decision-making, guardianship, conservatorship, or whatever else is on your mind.